There is a new case from the North Carolina Supreme Court that clarifies when compulsory counterclaims must be brought when the statute of limitations is looming. That sounds like an absolutely riveting topic, but this case actually is interesting. It explores some nuances in the way our legal system works here in North Carolina, particularly with regards to precedent and when it can be overruled. Let's talk about the case. So the case is Upchurch versus Hart Builders Incorporated. The facts of this case aren't really particularly important to the outcome, and the court only spends about one paragraph talking about what happened. This whole case arises from an accident that happened all the way back on December 19th of 2015. On December 19th of 2018, exactly 3 years later, the plaintiff filed a lawsuit against the defendant in New Hanover County arising from the accident. The very next day, on December 20th, 2018, the defendant filed an answer to the complaint and filed a counterclaim. A counterclaim is where the defendant brings their own claim against the defendant. Basically, what was happening here is the plaintiff was saying, you, the defendant, are at fault for this accident and caused my injuries. And the defendant said, no, you, the plaintiff, are at fault for this accident and caused my injuries. And so there's claims against each other. Here's the question. In North Carolina, you have 3 years after a motor vehicle accident to bring a lawsuit. It's called the statute of limitations. If you don't bring it within 3 years, it's barred. Well, the plaintiff brought their lawsuit exactly 3 years after the accident. So they're in the clear. The defendant, however, brought their claim 3 years and 1 day after the accident. So technically outside the statute of limitations. So is their claim subject to dismissal? Well, that's what this case is going to talk about. As a side note, I'm really curious as to how this happened practically. To have an answer and a counterclaim filed in 1 day. I mean, the plaintiff files their complaint December 19th, and the next day, the defense has already gotten an answer and a counterclaim asserted. They must know that this lawsuit was coming, and that makes me really wonder about what conversations were happening between the lawyers in the weeks and months and days running up to the filing of this lawsuit. So the plaintiff moves for summary judgment on the basis that the defense's claim is barred by the statute of limitations. The defense says no, it's not. The judge agrees with the plaintiff and dismisses the defendant's claim, leaving just the plaintiff's claim. And then the defense appeals that decision to the Court of Appeals. At the Court of Appeals, and this is the first sort of interesting, it's not exactly political, but internal politics of our judicial system at work. At the Court of Appeals, the Court of Appeals unanimously affirms the trial court's summary judgment order. So there's a panel of Court of Appeals judges who all look at the case and all together with one voice say, yes, you, the trial judge, you got this right. Dismissing the case was the right outcome. In reaching the decision, the Court of Appeals relied on Pharma Research Corp versus MASH. And that case becomes really important. In Pharma Research Corp versus MASH, an earlier Court of Appeals concluded that counterclaims do not relate back to the date the plaintiff's action was filed, and that all counterclaims are barred by the statute of limitations if not filed prior to the statute of limitations running. Relation back is this concept that you get the benefit of the date something else was filed. So what the defense wants to say is this action, this case was begun prior to the statute of limitations. When we file our counterclaim, we basically should get the benefit of the fact that this whole thing was started within the statute of limitations. So we should get to file all of our claims no matter what they are, so long as we could have brought them on the date the lawsuit was filed. That's basically the defense's argument. The plaintiff in the trial court says, well, no, that's not what the rule says. This Court of Appeals and Pharma Research said counterclaims don't relate back. And so if you don't bring them before the statute of limitations, then they're barred. Now, there's a really practical reason that that's a bad idea, which is that it promotes exactly this type of gamesmanship. You might have an accident where each party has a claim against each other, but both parties are maybe reluctant to bring a lawsuit, so neither of them does. But if one of them does bring a lawsuit, then the other one is going to assert their claims. They're just not going to stand there defenseless. I see this a lot in breach of contract claims. You'll have a contract, a business dispute that falls apart. And a lot of times if both parties walk away, it'll just die, won't ever be a lawsuit filed. But if one of them brings a lawsuit, you better believe the other one is going to assert every single claim that they have against the person that's suing them in the form of a counterclaim. So you can avoid that if under Pharma Research by doing exactly what the plaintiff did here, which is you wait right until the statute of limitations, right until the limit for them to bring their claims, and then you bring yours. And then the idea is that it'll be too late. They won't be able to respond quick enough to get in their answer and their counterclaims before the statute of limitations. Generally speaking, in the law, we try not to promote gamesmanship, and that's exactly what that rule does, but that is what the Court of Appeals said in Farmer Research. And so the trial court follows it, and the Court of Appeals, in this subsequent case, follows it. So the case gets appealed to the Supreme Court through what's called a petition for a discretionary review. Basically, it's where the losing party at the Court of Appeals says to the Supreme Court, hey, do you guys want to look at this anyway? We don't have a right to appeal it to you, because if the Supreme Court is unanimous, we don't have that right. But hey, Supreme Court, you want to look at this anyway? And the Supreme Court grants the petition for discretionary review, which is usually not a good sign for whoever is the other party. If the Supreme Court takes what's called a PDR, they're usually not taking a PDR just to affirm the case. If they're going to take a PDR, it's usually because they're trying to change the law in some way. And that's what happens here. So the defense points to a case from 1874. It's called Brumble v. Brown. And in the Brumble case, the Supreme Court said a defendant's counterclaim does relate back to the date that the original action was filed. And therefore, they're not barred by the statute of limitations. If that case from 1874 is still good law, if it hasn't been overruled in some way, then that's the rule. It relates back. Farmer Research is wrong, and the Court of Appeals is wrong, and the trial judge is wrong. This all needs to go back, and the defendant does get to bring their claims. So why does the Court of Appeals think that Brumble is not good law? In Farmer Research, the Court of Appeals said that the Brumble decision was not good law. It was not binding anymore, because since that decision, the rules of civil procedure had been passed. And therefore, we're going to interpret the way that the rules of civil procedure work anew. And under our interpretation of the rules of civil procedure, these claims don't relate back based upon how the rules are written. The problem that the Supreme Court has with this decision, with the Farmer Research decision, and now the Upchurch decision, is that it ignores another case, which the Supreme Court ruled prior to Farmer Research, but after the rules of civil procedure had been passed. And the case is called Burcell, B-U-R-C-L, which was from 1982 and dealt with Rule 15 and how the passage of the rules of civil procedure affected how amended complaints function when they relate back. Not exactly relevant to our question here. Basically, though, the issue that the Supreme Court is having now, they say that Burcell already laid the groundwork for how this was to be interpreted. Under Burcell, I'm now mixing up the way I say it, this does relate back. Under Burcell, Brumble is good law. The problem with this, and what's interesting about this, is the Supreme Court is now going back prior to Upchurch, which is this case, and not just overruling the Court of Appeals in this case, but overruling the Court of Appeals in Farmer Research, because Farmer Research was wrong. The Court of Appeals is basing its decision based upon what Farmer Research says. The Supreme Court saying, well, yeah, but Farmer Research should have been looking at what Burcell says. Burcell is the rule, not Farmer Research. The Supreme Court explicitly says that the Court of Appeals erred in Farmer Research by not following Brumble. And we overrule Farmer Research to the extent that it conflicts with this opinion. So the Supreme Court now is reaching back to Farmer Research long after the fact and saying, oh yeah, actually, you guys are wrong in that case too. Here's the problem with that. Farmer Research was appealed to the Supreme Court. The Supreme Court had a chance to tell the Court of Appeals that it got it wrong in Farmer Research. And the appeal was denied. Supreme Court in Farmer Research said we don't want to look at it. So what's changed? Why is it now that the Supreme Court is wanting to go back and rule on Farmer Research when it wasn't when the Farmer Research case was pending? And what I would suggest to you, and this is the internal politics of how our judicial system works, is that the Supreme Court has changed. We now have a very conservative Supreme Court. And one of the things that conservative Supreme Court justices really value is statutory interpretation. And in their view, the statutory interpretation of Farmer Research was wrong. There is no stare decisis concept when you're dealing with statutory interpretation. If the statutory interpretation was wrong, it's always wrong. And there's no amount of time that can pass where it's not right to go back and fix it. So that's why the Supreme Court is willing to say, hey, not only are you wrong in Upchurch, you're also wrong in Farmer Research. And we're going to overrule that case too. It makes you wonder if you're the defendant who settled out of farmer research or whatever, are you now looking at this case and going, well, darn it, I was right. Too late for me to do anything about it, but I was right. The court also spends a little bit of time explaining why it gets to relate back. It basically says that the statute of limitations says that the action must be commenced within 3 years. In this case, action is the filing of a complaint. And so they say, look, the action was commenced within 3 years. And so therefore, under the rules, it gets to relate back. It's within the statute of limitations. The Supreme Court spends its second to last paragraph basically justifying its decision on the basis of judicial economy and justice and fairness, that sort of thing. They've spent the opinion already discussing why it's the right decision by interpreting the statute. And now they're sort of saying, look, and on top of all of that, this is just the right decision. We want people to resolve their claims on the merits. We don't want it to be based upon gamesmanship. We don't want people waiting at the last minute in order to try to put their opponent in a corner. We want people to be able to resolve their disputes on the merits. For that reason, this needs to be the rule. In addition to all the statutory reasons, this also just is the right outcome. This is the quote that I think really sums it up best. It may be that a defendant has the superior claim, but was willing to forego litigation for magnanimous reasons. Were this court to hold that the statute forecloses defendant's compulsory counterclaim, we would encourage plaintiffs in future cases to wait until the last minute to file suit as a means of defeating even meritorious counterclaims. Courts recognizing that if they put their stamp of approval on this rule, then plaintiffs who are worried about a counterclaim are always going to wait to the last minute to file their lawsuit so that the defendant won't be able to bring their counterclaim, even if the defendant's case is better. It'll be too late. Ultimately, this is a simple case that clarifies a relatively straightforward but important issue. What's most interesting to me about this case is sort of the internal judicial politics. When do we overrule a prior decision versus when do we not? When are we bound versus when are we not? I think the court gets it right in this case. If you found this video interesting or helpful, please leave me a comment to let me know to keep making them. And until the next one, if there's anything I can do for you, don't hesitate to reach out.